Good evening. I'm glad to see you all, despite the perturbations provoked by the weather. Thank you for joining us. I'm Danielle Allen, Director of the Edmund J. Safra Center for Ethics, and it's a great pleasure to be introducing this evening's speaker, Dr. Ayelet Shachar. I'm still not very good at exactly getting the pronunciation quite right, but I'll keep working on it, who is just an extraordinary political theorist and legal theorist. Also, in addition to her personal and intellectual qualities, she has just been a person who consistently takes on the hardest and most important issues. And I think the questions that we're digging into tonight and in a workshop tomorrow about migration and borders and citizenship and political membership are at the heart of, I want to even go so far as to say, every single most important political and ethical issue facing societies today. So really, there couldn't be a more important thing, I think, for us to be talking about than this question of how it is exactly we think about allocation of political rights and privileges and how that intersects with issues of markets, territory, labor, global finance, et cetera, many intersecting social phenomena. So Professor Shachar is currently the director of the Max Planck Institute for the Study of Religious and Ethnic Diversity in Göttingen. She is also at the University of Toronto, where she served for many years on the faculty and continues to have a visiting affiliation. She has a JSD from Yale Law School and is the author of many books and articles. Most recently, just out this fall, is a big, beautiful book. We now have a copy in the Safra Center, so you'll have to come have a look, called the Oxford Handbook of Citizenship, with, I think, 37 different essays in it. So come have a look, but a deep exploration of these hard questions. She herself is also the author of the 2009 book, The Birthright Lottery, Citizenship and Global Inequality, and the 2001 book, Multicultural Jurisdictions, Cultural Differences and Women's Rights. She is always a person who writes and thinks with great lucidity, and simultaneously to her clarity and in some sense sort of accessibility of her argument, nonetheless asks us to take some of the sort of most given, overlooked concepts, things like citizenship, and reinvestigate their deep roots and their far-reaching consequences. So I'm just really thrilled to be able to welcome her this evening. And I should add too, we are so lucky she had to get here. My goodness, a theme, a topic about migration and movements. Poor Ayelet, with the weather and the transportation, had to fly from Berlin to Frankfurt to Toronto to Montreal to Boston to be here, okay? So please give her the warmest possible welcome.
Good afternoon. Bonjour, buenos dias, guten tag, shalom, assalamu alaikum. It's such a great pleasure for me to be here. And as Danielle mentioned, first of all, thank you for that absolutely overgenerous introduction. But as Danielle mentioned, I really did travel for about 30 hours to be here. So if something is not coherent, it's not me, or it's the jet lag. So I have a perfect excuse now. But really, it's a pleasure for me to be here. We have been working on this workshop, which will take place tomorrow, for quite a while. And it's just an added value. And for me, really a pleasure to be able to deliver this public lecture here under the auspices of the Edmund J. Safra Center for Ethics and also the Mahindra Humanities Center here at Harvard. So what I would like to do in the time that we have together is hopefully to take you with me on a journey. And in this journey, I wish us to explore how the basic tools of public law, by which I mean to speak about three different components: legislation, regulation, and case law, how these combined elements of public law have become, or this is what I will try to persuade you, have become key components in reinventing one of the most classic dimensions of sovereignty in the modern era, namely territoriality. That's why the title is The Shifting Borders, and you'll see we'll talk about justice, a little bit about territory if we have time, also about markets, and definitely about migration. And in terms of dividing our time, I want to split it into three parts. The first part, I want to share with you the background and motivation that actually got me into this project of the shifting border. Secondly, I'll identify the main contours of this new conception of territoriality, the shifting border. And you'll see it's a border that's, I will claim, does a lot of work in terms of migration control. And I will also try to explain some of the techniques which are used, the legal techniques, and later on we'll get to some of the normative aspects. But I also want to claim that this argument, and if you wish, please challenge me during the Q&A. Also, I want to suggest that it has a significant explanatory power, that it helps us understand some of the developments that we see in the world around us in terms of migration regulation. And what I'll do in the third and final part is I'll try to move from the more positive analysis to the normative, and I'll do a move which I know is going to be risky, but despite the risks, I'll actually do it. That is, I'll try to offer some reconstructive ideas, some ways of thinking about the relationship between law and territory, space and political organization. And I will try to engage, in other words, in this perilous act of seeking non-ideal institutional design solutions to seemingly intractable dilemmas and problems. So that's our modest plan for the next 45 minutes or so. So first, I want to tell you a little bit about the background for this particular project. It really grew out of my personal experience. I moved to Germany in summer 2015 to take a position as a director with Max Planck. And as it happened, this particular position, which I knew would focus on questions of citizenship, migration, and diversity, I came to Germany in summer 2015. So literally with the refugees. And actually the first year when I was introduced, everyone said, oh, she came with the refugees. And given that I really was unrooted, it seemed quite fitting. But you'll even note, even the title of that summer, some critical scholars will call it the summer of migration. That's how you would find it referred to. You know that most of the literature would refer to it as the refugee or the migration crisis. So even how we label that particular very unique summer is interesting in and of itself. But obviously I came to a new place. I was trained in North America, so Europe was really quite new to me. And I felt I had to deal with the pressing reality of these waves of immigrants, of migrants who came uninvited, who claimed asylum. And as you recall, also many lost their lives on the way or had to take very, very dangerous routes of passage. So I was really trying to understand or figure out what might be the human rights implications of the kinds of regimes that we have that have actually led people to have to take these very dangerous routes of passage to gain asylum in the first place. So this would give you the context, and my claim, which is a critical claim, is that what we're witnessing states do, despite the fact that we have seen the summer of 2015, it was an exception. What states are trying to do is to create what I'll claim is a striking new framework of migration regulation. And I'll try to persuade you that this new shifting border regime actually endows those in power with a whole new means for crafting the boundaries of inclusion, exclusion, mobility, immobility. And I also want to claim that because this is done in such a technical legal way, some of the details I'll try to convey to you, it's also frequently done behind and beyond open democratic debate. Now, if you're a newcomer to this field of migration and citizenship, I think it would be quite reasonable to expect that the legal boundaries of inclusion and exclusion, I think the basic assumption is that they would correspond with the kind of recognized bold and fixed borderlines that we will find, say, depicted in our world atlases. So this is the common assumption, that the border is literally where the border is marked, say, on a particular map. But the kind of reality that I want to describe to you is one which these borders, the new fixed shifting borders, oftentimes do not coincide with those comprehended and indeed, I want to say, created by the words of law. And instead, what we're witnessing is a border which is in flux. It's in flux because it's simultaneously more open and more closed than in the past, and the very legal construction of the border itself is shifting. It's shifting because at times, as I will show you later with some concrete examples, it's penetrating into the territory, it's moving inland. In other cases, it expands literally half the world away from the territory, which is protected. And by having this ability to stretch or flex and shift the border, sometimes it appears, sometimes it disappears. Again, I'll show you some concrete examples, so this would seem more concrete. I want to suggest that this new power to shift the border actually has very dramatic consequences in terms of democratic accountability, which I already mentioned, in terms of human dignity, given that we're looking at human rights, and in terms of global disparities in attaining access to both territory and, based on territory, also access to membership. And of course, given that we're looking at individuals who are trying to reach, in most cases, countries which are more stable and more affluent than their home countries, the distributive implications are quite dramatic in the sense of they affect mostly those individuals who received the short stick in the birthright lottery. So in that sense, it's also very connected to the kind of questions that I've dealt with before. So just to summarize, the shifting border, the basic idea is that the border itself has become a moving barrier. It's an unmoored legal construct that no longer is tied to a fixed territorial location. And what I want to do by charting this new legal cartography or reconstruction of the borders and of the membership boundaries that these borders protect, I want to show first the tremendous creativity which is actually involved in this idea of the shifting border. And I think it's significant. We need to capture that. But it's not only a significant creativity, it's also a significant set of new risks that are attached to this new legal innovation. And I want to suggest also the public powers that these legal innovations both invigorate and propagate. So that's roughly the framework that I want to suggest. And I already mentioned partly why the reason why this is interesting is because it's very, very hard for us to fit this new reality with the kind of theories that we have that actually think about borders either as static or as disappearing. We think about borders either as open or as closed. And I want to suggest to you that really the unique and to some extent quite perplexing feature of this new shifting border or this new shifting border landscape is the fact that countries can actually simultaneously engage in what seems to be absolutely contradictory. That is, they can both open the border to those individuals they wish to bring in, and they also can simultaneously engage in closing the borders. Again, and I cannot defend this proposition here, but I claim elsewhere that they do so quite selectively. That is, when they seek to open the borders, states are now very, very, very adept at bringing in those individuals that they desire, that they see as valuable potential new migrants. Specifically, this would be individuals with specialized skills, with superb talents, or increasingly with deep pockets. And at the same time, the very same countries are also erecting higher and higher walls or legal walls to block out those individuals which they see as either unwanted or as too different. So this is the kind of paradox or the kind of regime in which we're operating. And as I said, it's much more fluid and flexible than the kind of borders that we typically think about. And partly the reason why I'm engaged in this project of the shifting border, I think that we currently are even at such a basic stage that we don't even have the conceptual language to really fully capture this new reality, just to describe it, later on to hopefully critique some of these rapid changes. And that's really partly the motivation of my presentation today, and hopefully we'll engage during the Q&A. I really want to get your responses and to see whether you think it does manage to capture something unique. So, as I mentioned, this is the new universe in which we live. Now, I promise you in terms of the context to also just say a little bit about markets. I'll just say something very, very brief about this, and then I'll return to our main theme, which is the reinvention of territoriality. So for me, when I mentioned to you, I came to Europe, I was confronted with this new reality, not just myself, everyone else. Policymakers had a much, much heavier duty than any of us scholars. But I was thinking already about these questions of territoriality and how states are trying to redefine membership boundaries in the context of citizenship, in the context of another project, which I'll just mention here very, very briefly, which is entitled Olympic Citizenship. And in this particular book, what I'm doing is I'm trying to look at three cumulative changes that are occurring, changes to territoriality, changes to cultural definitions, and also market-oriented influences in terms of redefining citizenship and who belongs and who does not belong within the political communities and our political communities. And I suggest that these three grand processes, the territorial, cultural, and economic change, are really proactive ways for states to reinvent and reshape citizenship. And I take citizenship seriously as perhaps one of the most influential political institutions and ideals of the modern era. And I suggest that states are actually taking on these kinds of changes both expanding and narrowing their membership boundaries through this trilogy of territory, culture, and economics, because they are trying to deal with what they perceive as growing uncertainty. That is a more globalized, more interdependent, and more volatile world. So within this context, states are trying to find a way to regain control. Within this project, the third component, the economic, looks at human capital. I have no time to describe this to you. I'll be happy to do so later on. But the other thing that I do want to mention to you is capital, because really here we're seeing some of the most dramatic changes that states are really quite explicitly bringing in individuals on the basis of their economic net worth. And not only that, I put up here, let's see if this works. Yes. I just published a piece on this in Ethics and International Affairs where I talk, I didn't actually, this is what I wanted to show you, sorry, the marketization of citizenship. So in this particular short piece, I'm just mentioning it because what I'm doing there is I'm looking at the United States, and I want to call your attention to a visa, which I don't know if you know. It's called the EB-5 visa. It's a golden visa. It's a visa that allows individuals who are willing to put in $500,000 to get a fast track to the green card. And these are called the parachuters. They need to have no connection to the political community, pretty much other than transferring their money. It's a passive investment. They don't even have to be active investors. And I contrast the parachuters with the dreamers. As you all know, the recipients of DACA, which are now have the sort of deportation literally hanging over their head. And I want to suggest that, again, these kinds of changes require us to think through what it means to be a citizen, if we can actually allow access to membership to individuals who have nothing but material investment, whereas individuals who grew up being American cannot gain access to citizenship because of a very, very harsh law that the United States has. And there's no way for them to regularize. And if they came as kids, no one is even claiming that it's their own wrongdoing. So to some extent, I want to suggest to you that something is occurring with this very same concept, and I want to draw out these kinds of contrasts. Now, I could speak about this for hours. This is not our talk for today. I'll have to come on another occasion, but just to give you the intellectual context. So hopefully now that we have spoken about this, we can return back to the main topic of today, which is really the reinvention of territoriality, as I mentioned. And I really want to explore the relationship, the harsh relationship, I will claim, between or encounters between bodies and borders. And these encounters between bodies and borders really provide us with quite concrete illustrations of much broader conceptual and theoretical concerns that we have, that is tensions between the relationship between sovereignty and human rights, security and freedom, national interests, and universal obligations. So let us begin. So I want us, if you could enter a time machine, for there are enough people in the room who will actually remember what I'm talking about. If we were to move back in time to 1989, you remember the fall of the Berlin Wall. At that time, there was a tremendous sense of optimism, I want to suggest, or that's my reading of the literature at the time. That is, the thought was that globalization would lead to greater human mobility, to the rise of international human rights, to the belief in personhood, that is, personhood as a category that would potentially replace some of our other organizing paradigms, such as statehood, nationhood, and citizenship. Now, if we fast forward in time, at the time when the Berlin Wall fell, there were 16 border fences around the world. 1989. And as I said, the thought was that borders will become relics of a bygone era. If we fast forward to today, and this is the most recent count, there are 70 border fences throughout the world, either completed or under construction. Interestingly, this trend began prior to the summer of 2015, but clearly it has accelerated ever since. But this is a very, very significant transformation. Now, in terms of the location, we've seen these border walls popping up across the world. I'll just provide you a couple of examples. You might know about the Spanish enclaves in North Africa, in Morocco. There's a border wall now between South Africa and Zimbabwe, Saudi Arabia and Yemen, along the very extensive India-Bangladesh border, between Brazil and Bolivia, Norway and Russia, Bulgaria and Turkey, and the list goes on. And of course, the most famous border wall is in this country, of course, the US-Mexico border. We're not going to get into that, but you can ask me questions about that later on. But for me, the puzzle is, why are we seeing these border walls and steel fences? Why are they popping up? And why do they seem to continue to signal, even in an age which is presumably or supposedly post-Westphalian? How could it be that we're seeing these physical barriers? And why is it that they seem to have a very powerful they seem to be a powerful measure, at least politically a powerful measure, to regulate migration and mobility. There are actually some fascinating studies that show that they don't stop mobility. It's just that the routes change. But nonetheless, it cannot be that more than 70 border walls are being erected worldwide, and there's no motivation to do so. So it's partly the fascination with this kind of a development. But for our purposes, I want to just point out that instead of the vision of the disappearing border that was very, very prevalent after the fall of the Berlin Wall, clearly we're seeing something different. We're seeing the rise of these very visible and refortified manifestations of real or imagined sovereign control. So these are the 70 borders that we're seeing. I could have given you a map of where they are, but literally this is changing almost by the week. But after hopefully I've convinced you that these are significant, my claim today is actually the contrary. That is, I want to suggest that as important as these border walls are, again, in terms of separating, many of these borders actually separate the haves from the have-nots, and it could even be the have something and have very little, but they are clearly mapping economic differences, at least symbolically, and in some cases also practically. But I want to argue that the far more interesting and unexplored kind of borders and more innovative phenomena, at least from the perspective of states, are not these visible, marked, fortified borders, but in fact these very highly sophisticated, invisible borders that, as I'll explain to you in a minute, some of the legal techniques, shrewd legal techniques that actually permit states to rely on these very invisible borders or shifting borders, create a whole new conception of the border, and this new conception is the one that I want to investigate with you. And the shifting border, unlike the traditional border, which is reinforced through a border on a physical marked line, the shifting border, what is unique about it is that it's not fixed. It's not fixed in time, it's not fixed in space, it's not fixed in place. That is, it's really a movable border. And instead of relying on a specific frontier location, which is the familiar wall and the kind of new walls that we're seeing, the 70 new walls are always on a fixed line, or a fixed, sometimes disputed, but nonetheless one which is recognized as the end of one territory and the beginning of another. The shifting border relies on what I will refer to as laws admission gates. And because these are legal gates, laws admission gates can move. As I mentioned to you earlier, sometimes they contract inward, sometimes they really expand outwards. They are appearing, reappearing, and they have dramatic implications, especially for the rights of non-citizens and any migrants that encounter these borders. And by locating this shifting border as an alternative to both the static, familiar static version that we see actually through the border walls, or the theoretical conception of disappearing borders, I want to suggest to you that the shifting border actually provides us a better, a fuller account of the kinds of patterns of change that we are witnessing in the world around us. So let's turn to a few examples which hopefully will convince you that we're seeing a complex, multi-layered, ever-transforming borders, one which is drawn and redrawn through the words of law. And I also want to suggest to you that this invention, which some have referred to as the near obsession, I think it's actually a good term, the near obsession of wealthier countries with reimagining their ability to control mobility, occurs through legal, not illegal or not extra-legal measures. And this is partly the fascinating, to me as a lawyer, the fascinating aspect. States are really trying to walk the line. They're saying they're acting within their obligations. But as I will try to convince you, these sophisticated legal maneuvers in many, many ways really act at least against the spirit, if not the word of the law, both domestically and internationally, although states claim to do otherwise. But I think it's significant that they're claiming that what they do is within the boundaries of the law. And you'll see later on when I get to the reconstruction, I actually play on that sense. Because if states are saying we're just acting outside of the law, there's not much you can do. But if they're claiming that they're acting within their own obligations, obviously that's a way to catch them or to say you're not really fulfilling your obligations, therefore we might have a different interpretation. So let's now turn to a few examples. Just after I've told you all these things about the shifting border, I want to provide you a few examples. So let's first start with the United States. So as some of you may know, The U.S. A specific regulation within the U.S. regime of the Immigration and Nationality Act is a procedure which is called expedited removal. Now, when expedited removal was introduced through legislation, I have to say not a lot of people actually paid attention to this new provision. But this new provision has actually turned out to be quite significant. Why is this new provision significant? It's a legal provision that actually states that frontline officers or border agents are permitted to expeditiously remove individuals who reach the border. So unlike the standard situation where you actually have a full, say, asylum hearing if you're making a claim, in these cases, if you cannot establish credible level of claim that you might be successful in your asylum claim, or if you're just entering without permission, you are moved back immediately. That's why it's called expedited removal. So that's the declared intention of this particular piece of legislation or amendment. But in addition to this expeditious ability to remove individuals, what this particular small legal change permits is not only to stop individuals at the external border of the United States, but individuals who are detected up to 100 miles away from any U.S. land or coastal border can be expeditiously removed. In effect, what this change does is it moves the border from its fixed location at the country's territorial edges into the interior. Now, I want you to look at this image because you might say, come on, it's just 100 miles. How much of a difference could 100 miles make? It turns out, actually, that if you look at the most recent U.S. census, within this 100-mile range from the coastal or territorial borders, 2/3 of the population of the United States actually reside within this 100-mile zone. Or another way to put this, 200 million people live in this malleable or movable border zone. So much so that the ACLU has labeled this 100-mile zone as a constitution light or constitutional free zone operating within the United States. Now, once you have this border, this constitution light or constitution free zone, it actually has very significant implications. For example, it means that it's permissible, again, with operating within the boundaries of the law, to set up checkpoints without any probable cause, which normally would be the kind of preliminary requirement that you would need to stop someone. Now, under expedited removal, within this 100-mile zone, remember 2/3 of the U.S. population reside within this 100-mile zone. It's possible to set up checkpoints on highways, on ferry terminals, on buses, on trains. Some of you might have actually witnessed this because sometimes it's the train that actually goes through Boston actually has immigration officials that are doing these random checks, and what they do is they basically ask you for proof of your legal status, a right to remain within the United States. Now, we're typically used to having such governmental surveillance power and authority when we move and when we are mobile, but usually we expect this to occur when we cross an international border. But what is occurring here is that this very same powers are now spilling into the interior. So that's the kind of idea that I have about the shifting borders. And again, if you want just to get a sense of the numbers, the whole state of New York fits under the shifting border within the 100-mile zone. Florida, which is another migrant magnet state, and the governmental agency which is responsible for implementing this expedited removal power, DHS, the Department of Homeland Security, has gone on record to declare that in their view, potentially this border enforcement power and measurement may well extend nationwide. So keep this in the back of your mind. So their idea, and in fact, there is a statutory way to read their interpretation as a plausible one. It probably will not happen for constitutional reasons, is to have this orange ring to all of that to be the whole United States could be orange, meaning that there's no distinction between the interior and the exterior. The whole country becomes a border. So this is our first example. Let's turn to a second one. We're now moving to Canada, through which I came through this morning. So Canada, just given its geopolitics, has perfected another technique of the shifting border, a technique which is officially referred to as Interdiction Abroad. Interdiction Abroad means that effectively Canada has relocated most of its immigration regulation activities to overseas gateways, and most of these, just for reasons of the people who travel to Canada, most of these gateways are located now in Europe and in Asia. And Canada has migration integrity officers, or liaisons officers, as they are sometimes referred to. These liaison officers, or individuals that they train, now conduct border control activities as a matter of course regularly, as a way to control who enters Canada. So most likely, if you're flying to Canada, as the vast majority of individuals do fly, just given its geopolitics, you will actually have your review of your documents, your ability to enter Canada, occur before you even boarded the plane that is supposed to take you to Canada. And not only that, as you probably know, any of you who have traveled, a lot of these regulations now have been actually downloaded to third parties, private actors, airline personnel, but also in some cases, just private firms that are doing the document review. And again, they're doing this before you left. It means that if you're stopped, if they believe that your document is not valid, you have no legal recourse, you have no legal remedy. You can complain to the airline, but you have no claim against Canada because you never reached Canada. And constitutionally, this is not deemed to be a legalized entry, and therefore there's no remedy that you have. Whether the same person, if they would have gotten physically to Canada, landed on the territory, they could have made an asylum claim. Even if they are irregular migrants, they could have made certain claims. They cannot do this because the connection between the individual and the territory, which is currently the legal basis for claiming these kinds of rights, is broken. So that's what I mean by the shifting border. So in the US, if we've seen the border bleed into the interior, in this example, and there are various others, we're actually seeing the border stretching outside, well beyond the territorial frontiers. In our example of Canada or other countries that are using precisely the same technique. And what is interesting, this is an official doctrine that Canada has established. I'm just going to read you a little bit from the official documents that describe this shifting border. The basic intention is to push the border out as far away from the actual territorial border as possible. And with this new conception, and this is this sort of half onion that you see sort of here, the old territorial border, which would be the territorial border, here it's this land border, is conceived as the last barrier to mobility rather than the first. So this is the kind of shift, because ideally for Canada, you should be regulated here in the country of origin. And all of these are different steps where you should be controlled, you should be regulated if you have no authority to enter the country. So just moving to a third example quickly, Australia. Australia is really quite a fascinating example, because even I would want to suggest that even more explicitly than Canada or the United States, Australia has really relocated its border, and again, it did so through the words of law, creating, and again, this is from official government documents, a distinction between the country's migration zone, which you see there in yellow, and Australia as we would know it on the map. So you actually see that the yellow zones are within a territory that's labeled as Australia, but for legal purposes, this excision zone, this migration zone, has a different status. And this these yellow areas, the excision zone or this excision policy, was introduced again through law, the Migration Amendment Act of 2001, and it was amended in 2005, and then again in 2013. And each time there was an expansion of this notion of the excision zone. But what this legislation does, in a nutshell, is it authorizes Australia's immigration officials to remove asylum seekers, even if they manage to reach its now excised territory. So this is why this is actually quite radical. The idea is that even if individuals reach the territory, which normally, as I mentioned to you earlier, is a way to activate the whole process of protection, because legally those yellow areas are not Australia. Australia claims that although they physically arrived, legally they never arrived, and therefore there's no set of obligation that arises from this actual territorial arrival. So legally they never reached the country, although of course this is a legal fiction. They did actually arrive, and in most cases this kind of legislation only applies to individuals who arrived by boat, many of them especially from Indonesia. And Australia, for a host of reasons, is very, very nervous about these unauthorized set of arrivals. But in terms of the implication, this legal fiction affects the procedural rights, the substantive rights that asylum seekers and other irregular migrants would otherwise would have been entitled to had their physical arrival been recognized as real arrival. But because of the excision zone, Australia basically says you are not here. And what one other component of this legislation, and I don't want to be harsh on Australia, but their policy really is quite extreme. This new legislation also eliminates the possibility of judicial review. So to some extent, we're not just seeing the redrawing of the territorial border itself, but also legality is being attenuated. That is the fact that you cannot claim the kind of rights that you would have normally been able to, and also the fact that there's no legal review. Judicial review means that to some extent, again, you have no remedy. Again, with this case, the extreme case of actually establishing territorial arrival, but the excision zone does not permit you to claim the kinds of rights that you normally would have been entitled to. Now, I want to report to you that Australia in 2013 expanded its idea of the excision zone, and now, through legislation, the entire territory of Australia is now legally defined as an excision zone. And in effect, what it means that the border applies literally everywhere and nowhere at the same time if you are in Australia without permission. So the whole territory now counts as non-Australia for these specific entrants. And now, in addition, and again, just 2 more minutes on Australia, just because I want to give you a sense of how transformative these changes are. Given that individuals do arrive, Australia had to face the question, okay, if they're here in Australia, they cannot claim status in Australia, what do we do with these individuals? And the idea that they came up with, or one of their ideas, was to transfer individuals who came to the excision zone to offshore locations. Here we have on our screen here, Nauru, which is literally 4,000, it's almost between 4,000 and 5,000 kilometers away from Australia. It's a remote island. Individuals are there now for years while they're processing their claims. Australia is processing their claims. But as part of its hardline policy, Australia wishes, or the intended claim that the migration zone is, the excision zone is required, is in order to deter human smugglers and irregular migrants from arriving to the territory. And therefore, Australia not only ships them now to these offshore locations, but even if their claim is found to be credible, which a very high percentage of the individuals actually do receive refugee status, they will never be returned to Australia. It's the original sin. If you came to the excision zone, Australia never, ever, ever permits you to go back. So I just want to give you a sense of how extreme this new invention is. And again, this is by a country that otherwise has a tremendously generous immigration policy towards other individuals that it sees as being as worthy of arrival, or individuals that they would define as asylum seekers that they wish to take in, but they just wish to stop the boats coming in, and that's their policy. And again, this is the last item that I'll show from Australia. This No Way ad is a public ad. You can look it up later on, Google it. It's a claim that says, even if you arrive, this is just a public policy advertisement of this policy. Even if you arrive here, we will never allow you to stay. So this is a very explicit policy, and everything that I've described to you is just officially the policy that Australia has adopted. But I want to claim that this clearly blurs very, very significantly the lines between law and politics. It also seems quite punitive, overreaching, and as lawyers we would say it seems to really fail the test of proportionality. It seems like a very, very harsh response to this initial unlawful, in the eyes of Australia, arrival to their territory. And clearly Australia is doing this. All parties in Australia actually support the excision policy, which is striking in and of itself. And I read this as their response to voters who are very anxious about border control, about membership, about loss of control or potential loss of control. And as we all know, this is by no means a concern that only Australia is facing. So it's this loss of control and this attempt to show that countries are regaining control through these reinventions. Now, very, very quickly, just because I want to turn to the third part, but I want to turn our gaze quickly to Europe. Europe is interesting because the European Court of Human Rights on several occasions has actually ruled quite explicitly against the creation of what are referred to as black holes or gray zones, in which jurisdiction or the European Convention on Human Rights provisions categorically do not apply. So the European Court of Human Rights has really taken a very, very strong position saying there cannot be these places where the law does not apply. So the excision zone to them would seem quite foreign. They would suggest that this seems to be, there's some kind of a fallacy occurring, and it cannot be that law does not apply to a specific territory. Despite the fact that the European Court of Human Rights has been very, very explicit, Europe has actually in fact borrowed pages, if not really chapters, from the book of the shifting border. And I don't have the time to explain this to you. I'll just provide one example. Please ask me about this during the Q&A if you have an interest in this. But one clear example of this kind of policy is the agreement between the EU and Turkey. If you recall, it was signed literally 2 years ago. And that particular agreement saw the transfer of 3 billion euros and other inducements in return for Turkey's assistance in keeping people in the region, in the sense of prior to arrival and out of Europe. So the idea of not allowing individuals to come in, having them stopped at a non-EU country. And it's a classic example of what has been referred to in the literature as the outsourcing of migration and border control. And earlier examples of bilateral or multilateral agreements is actually quite interesting. The EU, qua EU, is actually very, very active in these kinds of agreements. The most famous one, the previous one that was actually later banned, was an agreement between Italy and Libya, which did exactly the same kind of interaction. But the basic idea and the basic critique that these kinds of agreements have received is that they absolve EU countries from their otherwise binding and very demanding human rights obligation by insisting upon concessions and collaboration from non-EU member states. And the claim is that these kinds of agreements, they recast countries of origins or countries of transit as the gatekeepers of the developed world, and they allow wealthier countries to insulate themselves from becoming laden with the very significant, I want to emphasize, the very significant legal obligations that they have actually taken toward refugees and other persons entitled for international protection. So it's not a regime that says we no longer provide protection. It just says you just cannot get here because we're blocking you prior to arrival. So again, this notion of the shifting border and why it has such dramatic ramification. And this is part of what in the EU is referred to as the externalization policy. And it involves, again, in the language of the EU official institutions and documents, a close partnership with non-EU member states. And these are programs that are sometimes referred to as the neighborhood policy, the Euro-Mediterranean partnership, the Balkan Stability Pact, as we're looking at the south, but there are also such agreements with the east, the Africa-EU partnership, and the list goes on. But in all of these cases, the idea is to try and establish or enforce migration control at the earliest possible stage in collaboration with these regions of origin or transit countries, and combining, and this is interesting, this is actually very specific to the EU, explicitly combining development incentives, including significant amounts of money, but also infrastructure, knowledge transfer. So this is an interesting kind of a policy. It has its positive sides and its negative sides with the investment in those regions involved, these non-EU states. And if you want to think about other legal instruments that are familiar, readmission agreements, safe third countries, the definition of certain countries as safe, even though it's not 100% clear that they are safe, but if they are safe, you can be pushed back to them, and the list goes on and on. So I could provide you a few other examples, but I think that for the purposes of our discussion, hopefully I managed to convince you that there clearly is something that is going on, and that it's far-reaching in the sense of the reinvention of the border per se. So we have those 70 borders, the physical refortified borders, but we also have these shifting borders, and I think we pay too much attention to the former and not enough to the latter. And I hope to have shown to you or to convince you that this not just the sheer reach and magnitude of the shifting border would require us to explore new ways to tame what has become really an almost boundless governmental power. Because with this authority, if the border is everywhere and nowhere, it's very, very hard to know where it starts and where it ends, and therefore this is what I mean by an unbounded kind of governmental power and authority, and this new dynamic technique of border control and governance. And my argument, and this leads me to the third and final part, is that in order to respond to this shift in spatiality of migration control, we really can no longer work with the kind of tools that we have, kind of conceptual tools and the kind of legal tools and theoretical tools that we have, because to a great extent, they are still deeply grounded in the territorial conception of statehood and sovereignty. And especially human rights jurisprudence still has miles to go to capture with the creativity that we have seen in terms of the use of governmental authority to regulate migration by relying on this everywhere and nowhere shifting border. And I think the organizing principle that can help us as we try and think about responses is that governments, without ever admitting to do so, are trying to develop this shifting border construct because they seek what they define as the gain of extraterritorial freedom of operation without the pain being that they would be subject to democratic control, to constitutional control, to human rights obligation, and restrictions, what at least immigration officials would see as restrictions on their authority. And I believe that this is both unjust, and I also think it's quite unstable. And also there's a deep irony in this current situation, because the initial idea of the deterritorialized space and deterritorialized agency and action was in fact really associated in the earlier stage with very progressive and human rights enhancing ideas. And it's interesting that the same kind of a concept was very skillfully, I have to say, and arguably almost repressively captured or hijacked by law and order agencies seeking to restrict and police mobility. So hopefully I've convinced you that this is a significant enough phenomenon for us to think about. And this really is a segue for me to get to the third and final part of the discussion. And here I want to suggest to you that to counter this really quite dramatic reconception of the border, we must adopt an equally radical reinvention of our responses to these new realities on the ground, because the tools that we have simply do not seem to be able to capture these kinds of new realities. And I want to suggest that we need to have a shift in our perspective. And this shift requires us to move from the very established, familiar, and in many cases actually quite justifiable focus or locus of studying the movement of people across border. This is what we typically do when we study migration or mobility. And to some extent, the focus that I believe this kind of a project requires us to do is actually it requires us to focus on the movement of borders to regulate the mobility of people. So instead of just focusing on the individuals who cross borders, because that assumes the stability of the border, we actually have to think about how borders themselves move, to some extent trying to anticipate or respond to the mobility of individuals that seek to cross them. And again, this reveals quite a paradoxical and almost paradigmatic shift that we witness in the political almost the political imagination and implementation of the sovereign power or authority to screen and regulate migration and manage global migration flows in a world which is actually filled with multiple sources of law. So the fact that there are multiple sources of law here actually assists states when they try to reinvent the border. They can shift between formal and informal, hard and soft policies, local, national, transnational, supranational, international. So all these layers actually here work in favor of the ability to shift the border and escape the kind of legal responsibilities that actually were attached to the once fixed, one bounded territorial border, which we have seen. And of course, the fascinating question is, can limits be imposed on this new authority, and if yes, by whom, how do we even go about this? And to address this last question, I'll propose two kinds of suggestion. One is really more legal institutional. It's a twofold legal institutional response. And I will close with a more complementary democratic action and political contestation kind of response. But I think we really need to have the two together if we want to have any change in this new world of shifting borders. But before I do any of that, I do want us to switch gears a little bit and to engage with perhaps what is the most canonical text on questions of refugeehood, statehood, migration, at least in our political post-World War II political theory literature. And I'm referring here, of course, to Hannah Arendt. And I want you to hear her words because they're quite significant. Writing after the atrocities of World War II and the Holocaust, Hannah Arendt astutely observed, and I'm quoting, "Suddenly, there was no place on earth where migrants could go without the severest restriction, no country where they would be assimilated, no territory where they could found a new community of their own. This, moreover," and this is Arendt, "had nothing to do with any material problem of overpopulation. It was, as she saw it, a problem not of space, but of political organization." And of course, the world has changed dramatically since Arendt wrote these words and since the publication of The Origins of Totalitarianism in 1955. But what has remained a constant is the fact that we still actually, the plight of refugees and displaced persons still is one of the biggest and most pressing human rights issues of our time. And despite her radicalism and groundbreaking thinking, Arendt's writing, which of course was a product of her own historical period, it's not a critique, it's just an observation, really manifests quite a fixed and rigid vision of territoriality, which to some extent shares a great deal with the static view of borders. So I haven't described that static view of borders to you, but I can do so later on. It's the classic sovereigntist kind of interpretation. So while Arendt is correct that political organization is at the heart of the predicament we face, not space per se, based on the analysis I offered, especially the emphasis on territories' malleability under the shifting border conception, I want to suggest that a productive response will actually reverse the order of operations. It will reverse the order of operations in the following way. I think we have to think about place and space as part of the solution, and then garner the political will and legal organization, the political mobilization to follow. Now, how in the world could this be done? This is a very, very, very large challenge. So as I said, I'm just going to leave you with two thoughts or two possibilities of how we can go about this. You recall that when I started my talk, I suggested that the shifting border disrupts established conceptions of sovereignty, territory, and legal spatiality. And we've already seen the manifold ways in which the shifting border really disrupts these traditional notions. But what I want to do now is actually push the argument a step further and argue that instead of ignoring this reality, as really the vast majority of accounts of migration, whether positive or normative, seem to do, a more promising and somewhat dangerous step is actually to borrow a page from the Shifting Border book, but I want to do this in a subversive way. And the basic idea, which obviously currently is more aspirational than applied, is to take advantage of the shifting borders' advanced technique of spatial and temporal expansion, but to take advantage of that new spatiality in a way that actually counters its stated goal of restriction. And more concretely, when a state or a country delinks migration control activities from its geographical borders, so all the examples that we have seen of the shifting border do this delink, I want to suggest that a correlated expansion of rights and protection for the individual must follow. And to give you concrete examples of how this could work, I'm going to describe to you two methods that would advance this kind of a result. The first one, actually the more traditional one for human rights, is to expand the extraterritorial reach of human rights. The second idea, which I will describe to you, is relaxing the fixation that states, that our legal regime, global and local, still has a fixation on territorial arrival as a basis or a precondition for securing protection. And I want to suggest that both of these components are a hinge-like strategy. They need to work together. And I want to provide some elaboration, if time permits, just to give you a sense of what it is that I'm thinking about. So the first method, as I said, is the more traditional one, and it can be summarized as follows. Human rights follow the border wherever it travels. So if the shifting border travels, so should the human rights that would have applied had a person reached the territory, the fixed old territorial border. And this would be a technique to rein in the shifting border. It would rein in the shifting border by ensuring that core human rights and constitutional provisions apply regardless of the spatial location where state border control actually was exercised, whether in the air, land, or sea. And the basic idea is really to try and close the gap, or at least minimize it. It would be hard to fully close it, but at least minimize the gap between the extraterritorial migration control that states seem to take advantage of and the standard protection that would have applied had a person reached the territory and if they actually got to the actual border, at least some procedural and substantive protections in some cases would apply. And I have to emphasize, it's not a basic idea of undoing the shifting border. I don't actually think that that's realistic, but I want to run with it. If this is what states are doing, I want to not allow them to have the gain and not the pain. I want them to feel both. If they wish to use this extraterritorial migration control, that's currently it seems to be within their prerogative, then at least the same kind of guarantees, the kind of legal and normative guarantees that would normally apply at the territorial border should apply. And I think that would take away a lot of the incentive for actually doing the shifting border. It's precisely to break this set of responsibilities that currently come. Now, technically, if there are any law students in the room, the way to do this would really be, it's actually quite, as I said, it's a familiar idea. We could just switch the legal basis for establishing responsibility. That is, instead of the traditional approach, which focuses on where the act took place, I would argue that a more fair and consistent approach in the age of shifting borders would actually require us to adopt a functional or a jurisdictional approach, and that would mean that the test would be what are the kinds of functions that occurred and what legal obligations would follow or become activated as a result of what is referred to in the human rights literature as well as in the case law as effective control by either state agents or their delegates, and I would include public and private delegates, because otherwise we'll see the states just shift all these responsibilities to private actors. It's a bit technical. I'm happy to talk about this during the Q&A. But the first line of response, the basic idea, is basically to switch the rationale of legal accountability. That is to bring the shifting border in check by expanding the kind of human rights or constitutional obligations that occur beyond the mere territorial instant to, as I said, the jurisdictional or the functional encounter. And this would fit very nicely with the kind of human rights jurisprudence that we are familiar with. If you want to hear some examples from the case law, I'll be happy to do so. At least the European Court of Human Rights has really provided some very strong language that would permit us to work with this. If you want to know some of the cases, here she is a famous case. India, very, very recent case just a couple of months ago. In both cases, referring to bleeding in and stretching outwards, the European Court of Human Rights has been quite strong in saying this cannot be a legal black hole or gray zone. So this would be a kind of example, and this actually, you should know, counters the US approach in the famous Sale case, where the US Supreme Court ruled that extraterritoriality actually does permit to break the link, and at least for asylum seekers, it means that non-refoulement would not automatically apply in the high seas. So we can talk about this later on, but hopefully you get a sense of the direction in which I want to suggest the first move would be. Now I want to add a second complementary approach, and that would be a little bit more substantive in the sense that given today's shifting borders, I think that we would need to rethink or go back to the basic principles. And the basic principle currently is that in order to gain protection, at least if you're seeking international protection as an asylum seeker, you have to reach the territory of a particular country. And in this way, by touching base, physically reaching a territory, you activate the mechanism of protection. And I want to suggest that instead of this standard legal framework, which really is a bit upside down, it requires those in international need to somehow get their bodies to the soil, to the territory or the border of a given country in which they seek to claim protection. Now, I have just described to you over the last, who knows, half an hour, all of these very sophisticated legal mechanisms that affluent countries are doing precisely in order to prohibit their ability of actually reaching the territory and establishing themselves, putting themselves in front of the legal authorities that could potentially grant them protection. And what I would argue here for is that we need to promote precisely the reverse or opposite logic. Individuals should be free to claim asylum or other forms of protection wherever they happen to encounter the shifting border. If the shifting border moves to them, why should it only be a border for regulation and restriction? Why should it not bring with it all the kinds of protections that individuals would have received had they actually reached the physical territorial border? So it's really turning the shifting policy on its head, and I want to suggest that the border should come to the individuals who are in need of protection. Now, if this sounds a little bit abstract, bear with me. I want to give you a concrete example that would actually illustrate how this could operate in practice. So you remember I earlier used Canada as an example of a country that really consistently relies on what's referred to in the legal literature as its long arm. It basically is extending its long arm to reach individuals long before they reach the country in order to restrict mobility or control mobility. But in 2015, in that summer of migration that I mentioned to you earlier on, Canada actually emerged as one of the global leaders or good doers in terms of swiftly airlifting and resettling, if you recall, 25,000 Syrian refugees, and the number has since now has doubled, so now the numbers are close to 50,000 in Canada. Now, how could Canada do this? Unlike Europe, people didn't reach its territory to claim asylum. It's just literally too far away. Instead, what Canada did is it brought the shifting border to them. It brought the shifting border both conceptually and also practically. That is, Canadian immigration officials were dispatched very quickly to refugee camps in Jordan, in Turkey, in Lebanon, where these immigration officials did what they always do. They conducted pre-screening, they did interviews, they did identity verification procedures that they need to do if someone is claiming asylum. And literally within a matter of weeks, which is unbelievably fast for asylum status determination, these reviews were completed. The individuals which were successful, the successful refugee claimants, were issued not only temporary mobility documents, which is what a humanitarian visa would be to allow you to get out of a particular place, but actually they received permanent residency, landed immigrant status in Canada, which immediately placed them on the road to citizenship. And this is in lieu of the deep insecurity or the state of limbo that asylum seekers typically face. Even those who reached Europe, even the lucky ones, so to speak, are now, many of them have an indeterminate status, which means that they may have to wait years until they actually know if they can stay even in Germany, which was the most generous country in terms of its having more than 1 million asylum claim processes introduced in 2015. So even the lucky ones, those who managed to touch base, those who managed to overcome all these restrictions of the shifting borders, even those individuals don't have the same security as the individuals who actually had the benefit of the shifting border come to them and grant them protection. Now, I want to be not to over-romanticize this kind of a solution. Obviously, we have an issue of numbers, how many people could actually come through the shifting border. It shouldn't just be Canada. In theory, if we think about redistribution or reallocation, it should be potentially any country in the world that would be able to absorb individuals. Let's just say if there's someone who spoke Portuguese and came and spoke with the Canadian immigration officials, if Brazil would be on board, that person might prefer to go to Brazil rather than to Canada. It should be part of that mechanism if we ever are able to create this global cooperation that is required in order to do so. But the reason why I say that I'm unromantic is that there's actually really nothing conceptually new about the way in which Canada used its shifting border. It's just that instead of exercising it as a gatekeeping border and a selection mechanism to restrict individuals, here it was in some ways revolutionary because the same machinery, so to speak, of the shifting border was used in the service of enhancing rights, of protecting individuals, of securing mobility, rather than insulating a very well-off country from those individuals who might want to come in. So this was really done by shifting the burden. Instead of asking individuals to touch base, again, this is a burden that normally falls on asylum seekers. Here the burden shifts to the state and its authorized agents. They are the ones who need to go far away, and as I mentioned to you earlier, they do so on a regular basis. There's nothing conceptually new. It's just a different use of the same mechanism. And the idea is to bring these determination processes closer to the people who are currently out of place, as they are sometimes referred to in the literature, wherever they happen to be, so as to provide access from afar to opportunities that otherwise are really open only to those who can afford to reach the actual border. And we can get into a whole discussion of who might be excluded by this territorial arrival. I would imagine that as a pregnant woman, it would be very, very difficult for you to take that journey. If you're elderly, if you're disabled, it would be a very, 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 very risky, in addition to all the other risks that individual would face. So actually we have a selection system already. It's just that it benefits those who are younger, who are stronger, who are more, in a sense, entrepreneurial, willing to take the journey to actually comply with the touch base. So no solution that we have doesn't have deep distributional and deep ethical concerns. But I want to suggest that at least this mechanism, if it could have a priority, a set of criteria and actually reach the individuals who are in the greatest need, if we can ever define that, that potentially is the advantage of using the shifting border rather than suggesting that only the ones who can actually make it, who can touch base, will be able to benefit from the generosity of these affluent countries, which, as I said, really do tie territoriality. At least the European countries really insist on territorial arrival. So just going back to Arendt, I think she clearly was correct that political organization is at the heart of the predicament that we face. But that's what I mentioned earlier about reversing the priority of our thinking. That is, I hope that scholars and activists might think about place and space as part of the solution, not only part of the problem, and then gain the political organization and the political will to follow. And more important still, if we think about space as a resource, not just a problem, it really could help us avert the basic plight, the basic concern that Arendt so powerfully identified, of not having any place in the world in which the rightless, the stateless, or the displaced can find refuge. And I want to suggest that our insistence on this old school, the static, old sovereigntist conception of space to find relief for refugees, asking them to arrive to our wealthy territory, just really prohibits all the kinds of opportunities and basic rights for individuals who might be in the greatest need. And if anything, we are punishing them in the sense that they have almost a Sisyphean fate of travestying and retravesting the terrains of the shifting border in order potentially to just be pushed back to square one. So the solution that I've suggested is by no way a panacea. It's this twofold strategy. Clearly has many, many other details that have to be worked out, but it would reach out to people out of place, and also just given the reality that, as you know, many people in the room would know, 84% of the current displaced persons in the world are in fact in the global south, and they are hosted by poorer countries. So the situation that we have is actually so dire that any kind of change, even if it doesn't resolve everything, would probably be somewhat of an improvement. And again, I don't want to, or my basic intuition or inclination here is not to allow states to hide behind territorial arrival as the requirement that, as I said, pushes asylum seekers, first of all, to take unauthorized and extremely risky, dangerous routes of travel, but also has deep unfairness in the kind of distributional touching-based requirements that it imposes. Now, there are many, many other things that I could tell you. There are other international responses, which of course others in the room could also speak about them. We can think about the Nansen passport, humanitarian visas. We can think about international collaboration. The point that I want to emphasize is I'm worried about the survival of the fittest kind of touching-based requirement, and I want to address that. And as I said, I'm using here the shifting borders subversively to try and respond that. And just, I know we're late, so before I close, I do just want to make two final points. First of all, I'm mindful of the fact that I'm speaking to you here at Harvard, at the Safra Center, a week before Passover begins. And as you may know, Jews around the world in Passover, really everywhere, Calcutta to Caracas to Paris, New York, Beirut, where have you, will recite the Pesach Haggadah. And they will close their Seder with the following very curious phrase, actually. And I'll say it in Hebrew. It's L'shana haba'a b'Yerushalayim, which literally means next year in Jerusalem. And it's not a biblical, Sarah could correct me because she took the Orthodox education. It's not a biblical, it's not a religious phrase, in fact. I think its first recorded use is found in the 10th century by a Sephardi scholar, rabbi, and poet, Yosef ibn Abitul. And he lived in the 10th century in Merida in Spain, the great time of Al-Andalus, when, of course, as you may recall, there was a great collaboration between Muslim and Jewish scholars, the golden age of interfaith. And it's interesting because his original phrase was actually inversed. He said, Be'Yerushalayim shana haba'a. You can do this in Hebrew. You can first say the time or the place. So he said first the place in Jerusalem next year. Now, as I told you, it's L'shana haba'a Be'Yerushalayim. It's inversed. But this phrase, of course, is an interesting one, and it could be interpreted in different ways. You can say literally next year in Jerusalem, sort of a diasporic people seeking to return to a homeland. Though notice that it's not a homeland, it's a city, it's an ideal, it's not necessarily actually a physical country, a yearning of, or the object of yearning is not a country, but we can talk about that later on. But I would say it could be interpreted in quite a different way, which is the way that I would favor. That is, it's the basic idea of an inculcating in each generation and reciting the Exodus from Egypt and remembering Egypt, the idea that individuals should think, this is what the Haggadah requires them, to think of themselves as their progeny, as if they themselves had left Egypt and had to be liberated from slavery. And partly interesting, it's a story of partly involuntary migration that actually freed them, liberated them from Avdut to Chirut. And this interpretation, as I mentioned to you, instills in us, in each generation, the strive to create a more just, a better, a more peaceful, more equitable world in which to live. And if we turn our gaze back to the United States, this really is, I'm closing, I want to suggest that the current administration has actually taken tremendous powers to itself, has given itself powers to use inland enforcement in a very, very expansive way They revoked the Morton memo on prosecutorial discretion. They introduced a host of, as you know, memos, administrative orders, and really sowing fear and trepidation in immigrant communities across this country. And you remember that I started with the dreamers. I think that the revocation of DACA is actually just the tip of the iceberg. These are the more privileged individuals. These are the ones that at least more than 80% of Americans would want to actually grant them status. But if we are in an era of tough talk and tough action on immigration, and these have become widespread, what is interesting, or what I want to leave you with, is the following thought, that we've actually seen at the same time new spaces of democratic contestation been created. It's new spaces that stretch the boundaries of the political, both above the nation state, below the nation state level. And here I'm quoting from Michael Walzer in a recent piece where he said, all of a sudden, everyone is talking resistance. From university campuses to sanctuary city community organizations, the list goes on and on. The politics of contestation is on the rise. And I think it's required because it provides a vital companion, if not catalyzer, for the kinds of legal changes, conceptual changes that I have advocated for. My bottom line is that in a world of shifting borders, states are unlikely to cede their authority over migration regulation anytime soon, and especially not in the current political environment. And under such circumstances, the kind of two-pronged changes that I've proposed, that is extending the extraterritorial reach of human rights while simultaneously relaxing the linkage between territory and access to safety and a chance for a better life, would actually offer us a more sanguine future. Hopefully, it would lay the foundation for a conceptual and legal shift that is long overdue. So thank you very much. I've really exceeded my time here.
Some time for questions, so
So I thought this was absolutely fascinating. You make a number of powerful, troubling, normative points, but I'm not sure I totally get the relationship. Is this on? Yes, I'm not sure I totally get the relationship between the normative points and the claim that we need a reconceptualization in the following sense. I would have said, coming in here, there are borders. By borders, I would have meant physical borders, and I would say in the current state of the world, there are lots of very hard normative questions about who should be allowed to cross those borders. Question number one. Question number two, what mechanism should countries be able to use to enforce their rules about who can cross the borders? And then question number three, which is sort of a subcategory of number two, what special rights, if any, should people get once they have succeeded in crossing the borders if they wouldn't otherwise have satisfied the rules? Those seem to me to be very hard questions. Many of the things that you say are moving, troubling, disturbing, but I'm not sure that I need to reconceptualize the idea of a border in order to ask those normative questions. And so do we need to reconceptualize the idea of a border, or can we just live with old physical borders and the very hard normative questions that arise about mechanisms for enforcement of rules about who can come in and who can't?
I think it's a great question, for sure. I'm not trying to suggest that we have resolved the issues with territorial, the physical fixed actual border. And I agree with all your three questions, but I think the third question really does have to, the shifting border or the reconception of borders and territoriality, which really comes with it, because countries have actually, in my claim, we're actually following what countries have already done. So in a way, it's a bottom-up kind of analysis. I'm not coming with an ideal theory. I'm actually working in a non-ideal way, saying this is the reality on the ground and how do we respond to it. But I think your question about territory and status, this is how I would rephrase your third question. For those who have actually made it to the territory, what kind of rights and protections might they have? At least in the United States, traditionally, you know, there's actually a long constitutional tradition of actually providing some protections to persons, especially due process. And if you can't actually reach the territory, you will not get even those slimmer protections of due process. So I think actually the fact that we are looking at the breakage of this linkage and the fact that individuals the uninvited individuals, as they would be referred to by states, can no longer even make this basic territorial connection actually matters significantly for the set of rights and obligations that states have. And this is why I want to do the move of saying we have to rethink this, because if states are successful, and the numbers are such, we always think about migration as a very significant transformation, which it is, but globally the numbers are actually very, very minuscule. It's quite striking that even today in the world today, less than 3% or roughly 3% of the global population is a migratory population. If you were to compare this to other kinds of mobility across, in the age of globalizations, ideas, currencies, of course, commodities, this is a very, very tiny percentage. So I think claims could actually, states would never say this, but I think they are unbelievably successful. Affluent countries are unbelievably successful in actually prohibiting mobility and restricting it. It's so counter to all of our political narratives, which are all about how borders have been breached and we lost control. This is the claim that we see in the political sphere. I'm not suggesting that it's not even, if you live in a small village in Germany and all of a sudden you have 1,000 migrants there who are, from your perspective, uninvited, you will see this as a significant transformation. So I'm not belittling that claim. I'm just suggesting that if you take the bird's eye view, states have been unbelievably successful. And I think partly because they are relying on all of these mechanisms. This is why I want to sort of go back to the basic and say, at least from asylum seekers, definitely the fact that they cannot reach the territory, again, especially under the European conception, would mean that they have no access to very, very high standards of protection that otherwise would apply. So I do think we can't actually avoid re-exploring how states are redoing or reinventing borders and territoriality. So we can continue that discussion later on, but it's not in any way to belittle. This is why I started with the physical border, which, as I said, some of the physical refortified border walls is significant, and definitely something is going on. So partly it's actually doing the work, partly it might be just, as I said, the symbolic politics, which has been an argument that political scientists have long raised, that it's really just playing to the fears of the population, and politicians just need to do something, and also you might be, as I said, blocking some individuals, but as even the data is such that people remain locked in or come through different routes. So it's not really about effectivity in a very standard way, but I think in a world where borders are shifting, if we just remain with our traditional more territorial grounded perceptions, I just think we're losing some of the questions, and also we can't see some of the injustices, because then if you just focus on people who arrive, there are enough problems, enough concerns, and also a lot of difficult real integration challenges with individuals who have arrived without any permission. I can tell you that I gave the Canadian example, so I want to return to that in a minute. The 25,000 number was a political promise by the then new Trudeau government, and that was part of the reason why they got elected. The previous government was seen as very punitive to refugees and asylum seekers. But the people who actually urged the government to slow down were none others than refugee reception organizations, and they said, we need time, because in order for us to actually be able to allow individuals the kind of care and attention that we need, so individuals will not just arrive today and gain status, but in 10 years will actually be able to become full members of this society in the sense of their belonging and in the sense of their success in the society. It's a tremendous investment in individuals. And in fact, Canada has a private sponsorship program, which basically a family or a group of 5 academics could sponsor a person for the first year and really take care of each and every of their needs. So I think it's a much more complicated question. And again, I'm not belittling the other issues, but I think we do need to actually do the rethinking.
Great. As always, wonderful and enlightening. I'm going to ask a less good version of Professor Fallon's question. It's very hard to follow Professor Fallon, but I'll try, or a little coarser version of it, perhaps. And this is to put it the following way. Sometimes in the talk, it sounds like you're really a true crit about borders, right? That borders are these invented, imagined realities, that they are, to the extent they're justified, one has to make a claim for their normative significance. The tie to territoriality is not a real tie, but something that we've kind of inherited. Other times, though, it sounds as though the border is a real thing, and you're talking about, should we go beyond the border? Should we extend the border? Is this a fair way to move the border? And I'm kind of curious, what's the real Shachar here? Like, what is the sense here? And just, to throw out a crazy example, I was thinking about pantsuit nations. I was thinking about Hillary Clinton while I was listening to this, and the idea of pantsuit nation. So I would never think of pantsuit nation as a kind of border, but it is in some ways an intellectual border or a kind of radically different way of drawing a political community. And I'm curious whether you think that's an absurd idea or whether, in fact, one could imagine a pantsuit nation.
That's actually funny because I can refer your question to Liav Vergat because he has just written about the digital communities and other ideas about how we could rethink membership communities. So yeah, they're actually the pantsuit is not the most radical one out there. But I think you are right to say, first of all, I'm permitted to say it's a shifting border talk. I'm permitted to be a shifting border person. But more seriously, I would say, I do think that as much as I wish to rethink territoriality, you're right, and maybe that's also the first point that was raised. To some extent, I am bouncing against that reality. So I'm not suggesting, I could in other works, but not in this one. In this shifting border text, I really am looking more carefully at what has happened to territoriality, to border control, to the kind of rights and obligations that come with being in a particular territory or not having reached it. So you're right that I am bouncing off the physical territorial border as my starting point, and to some extent my critiques also refer back to that. So I'm not really reinventing the border in the sense of saying either we need no borders at all. I think that would be a totally different argument, because then we have to think about what kind of political communities we wish to have. Do we want them to be democratic? Do we want them to be located in place and space and have some continuity? That's a different question, and others, Reiner and others in the room have written about that. So that could be one kind of an alternative. Or you could just say that to some extent you want to have open borders. I mean, there are lots of discussions that we could have about what could be the alternatives. You're right that here I'm really criticizing the kind of fixed territoriality, and I also, in the longer version, or in the printed version that I have, I want to suggest that countries are really playing a very interesting and self-serving game. That is, when they wish to, they go back to the static interpretation. So you can read the requirement of touching base as the classic sovereigntist territorial interpretation. You only arrive to a country when you arrive to a country. It's almost banal, of course. That's why I said this is the sort of world atlas kind of a view. How can you claim asylum if you have not reached a country? We do have a general claim, or a general right, but it becomes activated under our current regime when you touch base. Then we know which country should actually provide you at least the asylum processing component. It doesn't yet guarantee you anything beyond that. So to some extent, I'm countering this kind of a regime that we have. And I want to suggest that it's unjust in multiple and manifold ways. And to some extent, then I think you could probably say that I'm more on the critique of borders and their normative implications, and also really because I care about the individuals who are affected by these current shifting borders. To some extent, in that sense, I'm very grounded. I want to find legal, institutional, and political responses that would actually allow us to galvanize the kind of, first of all, imagination, and secondly, institutional apparatus that would help us do this. But I think this is what is strange about this example, which I was really struck as I worked on it. The apparatus is really there. The shifting border is already there. There's no concern. Other countries could do exactly what Canada did. There was nothing new. It was really, as I told you, it's that long arm that gets anywhere. It's flexing the muscle. So if it can be flexed for restriction, really, I don't see the logical or here even the legal argument or the normative argument to say it can only be used for restriction and not for rights protecting. If we permit that, then we allow states to escape any kind of responsibility. And then many of the achievements, the reason why we have constitutions is to some extent to have some constraint on government. So if they can just escape the territory and do all of these things, clearly I think there's something deep that is occurring. And I'm trying to capture this. So I said we don't even have the conceptual language. So to some extent, it's a very preliminary kind of a project. At some point, I think I put in the text that it's like mapping a terrain that we're just not familiar with. It's partly a mapping exercise, just saying, look, this is occurring. Let's think through the issues, and I'm not claiming in any way that these are the only suggestions. Maybe you'll come up with a brilliant one, or other people in the room. I mean, I think it's just opening up a whole space for us to actually have this exploration. But I think so much attention is focused, rightly so, or not rightly so, understandably so, on these border walls, and so much of our rhetoric is around those border walls that I want to expand the discussion and add space for this kind of a new kind of responding to these new realities on the ground. And as I said, just mapping them, bringing them to our attention, and then we can think collectively about how to resolve them.
Hi. So thank you very much. I found that fascinating. Yeah, so I'm French, and I'm following what's going on in France in a lot of details. I have family doing movies in the border with Italy right now. So I found this very interesting what you were saying about Australia, about the fact that there was a mainstream view that all the parties were agreeing with this new vision of the border, because I think there's something about the link between the political and the legal at stake in Europe and in France in particular right now, because what we have is that the politicians are overruling the law. So what is going on right now is that you have the army that is physically preventing people from accessing the points where they can give their asylum requests, and even minors. And so they go against all the laws of the French state. And so now they've passed emergency legislation to have the same system as what you showed in the US. But so I was wondering what you were thinking about this inversion of the hierarchy between the political and the legal, and because I think this is one of the most concerning things going on, is that the legal framework is not the rule anymore, at least in France. Like they constantly go against the law and they're punished by the law, but they keep going. So in terms of activism and in terms also of philosophical thinking, so how do we react to this inversion of norms?
Well, I think I really would need to know a little bit more about the French situation to say anything more solid. But generally, as I said, partly, and again, I don't know enough about the French situation. There could be emergency orders. There could be various ways to temporarily say we're sort of stopping the standard, the state of exception. We're sort of not in the regular situation, and therefore extraordinary powers could be used. In some cases, you have these extraordinary powers are extended over and over and over again. But I would have to treat those, for the analytical purposes of this project, I would want to keep it as a state of exception, in the sense that what to me is interesting about these legal maneuvers is that all of the countries that I've explored, and it was the United States, Canada, Australia, and the European countries, they all claim to be operating squarely within the boundaries of the law. This is why it's such an interesting discussion. And they would be very alarmed if someone said, but you're breaching the law. And they would have very, very smart lawyers try and write these rules in a way which would be very, very hard to challenge. The expedited removal in the United States had, if I'm not mistaken, had a 1 month period where you could actually challenge it. And then once that 1 month period passed, you could not go back and challenge the legislation. This is not illegal, you can do this, but we could say it breaches any notion that we have of rule of law and legality, especially if the implications turned out later on to be so dramatic. And as I said, at least the statutory authorization, I didn't mention this in my talk, is 2 years within the country throughout the whole territory. As I said, I don't think it would fly because of constitutional challenges, but this statutory authority is there in the act. It can no longer be reversed because, as I said, there was a very narrow window, and I think at the time people really didn't understand the kind of implications. And all that you need is a note in the Federal Register in order to do this. So it's a massive power, administrative power. And we could get into a whole discussion about that. But I think to me what is interesting about these situations is the fact that they are done within the boundaries of the law. And therefore I said, because I'm trying to turn this situation on its head, I'm actually suggesting that might be an advantage. Because if you want to claim something against it, you can say, you're claiming to be operating within the boundaries of the law. And the boundaries of the law also include some of these procedural and substantive protections. How could it be that they disappeared because all of a sudden you're in the excision zone or somewhere in an extraterritorial zone? One point I will make about France, actually France has had those waiting zones, as they would call it, long before the US. I think the expedited removal is actually a sort of a shadow of the waiting zone, which was introduced in French law actually prior to the 1996 change in the US. So this is actually an old tradition, but it's not, I don't think you're talking about that. Well, we can talk about it later on. Let's just allow other people in.
Well, I think honestly, I'm going to have to, despite the richness, there's so many questions in the room, and I'm sorry I need to cut the competition off now. We've gone over our official completion time. So thank you very much, everybody, for coming.